I did want to start out talking about you and your accolades, and I mean specifically, you've received numerous accolades during your career, including the California District Attorneys Association Prosecutor of the Year multiple times, and I know that you were commended as being one of the best prosecutors in the LA District Attorney's Office by then Chief of Police Daryl Gates and the acting commanding officer of the Robbery Homicide Division. So I just wanted to know, can you tell me a little bit about your approach when you were on the bench that led to such a successful career?
Well, I wasn't on the bench at the time. I was a district attorney.
Ah.
So I didn't hit the bench as a judge until after 30 years as a prosecutor. I started off as a law clerk for the Arizona Supreme Court. After I graduated UCLA Law School in 1964, I went to Arizona because there was an opportunity to write appellate decisions for the state Supreme Court.
Mm.
So I learned how to do good research and writing. And, I would do the drafts of what eventually sometimes became the actual written decision with very few corrections.
Mm.
So I had a really good academic background, experience-wise, and working under pressure, which put me in good stead as a lawyer because I was well prepared, and whenever I became a lawyer, to do anything I did because of the research I did as a law clerk for a justice on the state Supreme Court of Arizona. At the time, by the way, I handled a case you may have heard of. I was the law clerk and got assigned a very simple case to decide. An individual committed a rape robbery and was convicted, and his name was Ernesto Miranda. That became the Miranda, the famous Miranda decision. We were reversed. We affirmed this conviction 5-0, and were reversed by the U.S. Supreme Court 5-4. But at the time, we were correct. We followed the laws that existed. They just came down with a whole new method of requiring the police to give somebody their constitutional rights before a confession or admission could be admitted.
And I did want to touch definitely upon Miranda versus Arizona, and just for our viewers of this video, in case they didn't know, that's the law that says you cannot self-incriminate, and everyone knows it as you have the right to remain silent. Anything you can say.
Well, you can self-incriminate, but you can do it spontaneously without being asked any questions. But once you're in custody and under arrest, before the police can question you if they want to use your statement, they've got to give you your Miranda rights. Right to remain silent, being informed anything you say can and will be used against you in a court of law. If you can't afford a lawyer, one will be appointed for you, and so forth.
Yeah,
that's been the law since 1966.
And I have a question about that with Miranda. What was it basically that he was coerced into that confession? Is that what happened?
No, we ruled that it was a voluntary confession. They put it on tape. Everything was clear, and the U.S. Supreme Court said in the future, and as for his case when it was retried because it was reversed, you had to give a defendant who was in custody his constitutional rights, as I just stated. Prior to that, they just asked questions. But most important, they're told they don't have to talk.
Exactly.